Welcome everyone to our webinar today. Thank you for joining us. My name is Cameron and I'm a senior lawyer in LegalVision's franchising and leasing teams, and I'm joined today by my colleague Annalise, a lawyer in our team. We'd like to get started with an acknowledgement of country. LegalVision acknowledges and pays respect to the elders past, present and emerging, and the traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters are situated on, and on the various lands on which those of you are joining us today. Before we begin, a quick couple of housekeeping for anyone wondering. This webinar is being recorded and you will get a copy of this emailed to you at the end of the presentation. There is a questions box where you can submit questions you want us to address at the end of the presentation. And finally, once we're done, there will be a survey that's automatically sent around to all participants where you can leave some feedback, comments, or questions or suggestions for future topics. So in today's webinar, we're going to be covering a couple of topics relevant for every single franchisor. We'll start about the disclosure requirements under the franchising code and any requirements to update it. We'll then talk about guidance for managing marketing funds and ensuring compliance. We'll then talk about the new Franchise Disclosure Register coming in later this year. We'll touch upon the changes to civil penalties in the Franchising Code of Conduct and the new super penalties. And finally, we'll finish off with some investigations in the areas of interest covered by the ACCC. And as I said, save the questions for the end. Please feel free to submit them throughout the webinar and we'll get to it. So in this presentation, you'll see us talk about the Franchising Code of Conduct, or the code. I'm sure all of you know it's the mandatory code that governs and regulates the franchising industry and provides rights and protections for franchisors and franchisees to promote fairness, transparency, and balance. Now, the disclosure document is a very standard document required by the Franchising Code of Conduct. If you're a new franchisor, you will have had this on recently, but if you're established, you're already very familiar with it. It essentially sets up everything a franchisee needs to know about a franchisor and a franchise system in order to help them decide whether to purchase the franchise. Now, that can include information about the franchisor, its directors, its associates, their qualifications, skills, and experience. It contains information about the size, geographic spread, and location of franchisees in the network and some contact details. It will disclose details about the franchisor's intellectual property relevant to the franchise system, their requirements for exclusivity or supply arrangements, as well as give an estimated cost for setting up and operating the franchise business, plus information about solvency of the franchisor entity and much, much more. Now, obviously, a complete disclosure document is essential for a franchisee to get advice and do all these investigations and due diligence before buying in it. And this is why it must be provided along with your key fact sheet, a summary of the disclosure document, 14 days before the franchise agreement is entered into. Now, the key thing to remember, this disclosure document and key fact sheet are standard, and apart from some minor site-specific or territory-specific details, it'll be the same for every franchisee within a financial year. And Annalise is going to talk about how you update it year on year.
Perfect, thanks, Cam. So Clause 8 of the code requires franchisors to update your disclosure document and your key fact sheet no later than 4 months at the end of each financial year, so that's 31 October. This should be updated to reflect your current franchise systems, any changes that may have occurred, things like that. One element of this is your financial disclosure. So these are certain financial disclosure documents you as a franchisor have to provide every single year. If you've been operating for more than 2 years, you have a choice of either the independent audit report and a statutory declaration, or you can provide financial statements for the previous 2 financial years. If the franchisor entity has not been trading for 2 financial years, and that's 2 full financial years, then you have to provide the independent audit report. Generally, you should review and update your entire disclosure document, but in our experience, there are certain particulars that generally are updated every single year, and these include new franchise grants that have occurred in the previous financial year, any franchise agreements that may have been terminated or came to an end for any other reason, any changes to IP ownership, so any restructures that may have occurred or anything like that, any litigation or proceedings that may have come about in the previous financial year. Importantly, this now includes, under the code changes that came into place last year, it now includes alternative dispute resolution procedures as well. So that's arbitration, mediation, or conciliation. Any payments as well that you may make to, say, recruiters or any third-party agents who might recruit franchisees on your behalf, as well as if you're a franchisor who receives financial benefits or any other rebates in your supply of goods or services to franchisees, updating these details, which, under the new code changes, they are quite extensive. The big ticket item this year, in our view, will be Section 14, which is all the costs and fees associated with operation of a franchise business. With the current inflation, we assume that 99% of franchisors will have to review these fees and make sure they are accurate, specifically in light of the significant capital expenditure requirements under the code. You should be aware that if you fail to update your disclosure document or key fact sheet, you may incur civil penalties, which we'll speak to later. Although the purpose of this webinar is to kind of highlight your annual disclosure obligations, there are some interim updates that as a franchisor you should be aware of and we find are often forgotten. So these are things that if they occur throughout the year, you have to update franchisees as soon as reasonably practical after they happen. That includes like unilateral variations to your franchise agreement, materially relevant facts, which we'll provide some more information to later, any judgments that may have come against you as a franchisor or any associates, so that's anyone listed in your disclosure document as an associate or any new associates. Importantly, your changes to the operations manual generally don't fall into this category, but if you are unsure, if you think it constitutes a major change to the franchise network, you should seek legal advice to make sure if you do need to disclose those details, you're doing so. There is an exception as well to the updating of your disclosure document, which does not apply to many franchisors. But if you're a franchisor who doesn't intend to enter into a new franchise agreement this year, and you have entered into one or no franchise agreements in the past financial year, you don't have to update your disclosure document by 31 October. Be aware, however, that if one of your franchisees requests an updated disclosure document, you'll have to go through the process anyway and provide them that document. So although the exception exists, it doesn't apply in most cases, and you should be aware you may still have to update it. If you operate a marketing fund, there are further obligations that you'll have to comply with, which Cam will speak to now.
Thank you, Annalise. So a marketing fund, for those who may not know, it's a pool of money that each franchisee and in some instances a franchisor or its related entities will contribute to. And this will pay for marketing and advertising done on behalf of the franchise network generally. It's managed by the franchisor or one of its associates, and usually there is a level of broad discretion involved in what those funds are used for, whether it's online marketing, campaigns, TV, radio advertisement, flyers, brochures, discounts, and many, many more. And because there's discretion, the code requires that within 3 months after the end of each financial year, the franchisor provides a statement to all franchisees of all the fund's income and expenses. Now, this statement must contain sufficient detail about the kinds of expenditure that the fund covered in the previous year. There's also a requirement to have that statement audited by an independent company auditor, unless 75% of the franchisees who contributed to the fund say they do not need the audit report. This is something to keep in mind, that this 30 days will occur at the same time as your disclosure document updates. As Annalise mentioned, the disclosure document gets updated within 4 months at the end of the financial year. Marketing fund is a month earlier, 3 months. Now, failure to comply with this section may result in civil penalties, and depending on the extent of the failure to comply, the franchisors could open themselves up to additional liabilities for misleading and deceptive conduct, which is in breach of the Australian consumer law, especially if there's financial detriment caused to franchisees. And this could, in some extreme circumstances, lead to instances of franchisees having a right to terminate the franchise agreement. Now, I mentioned that the marketing fund statement needs to have sufficient detail, and there's been a significant case that looked into this issue a little bit further. You may have come across the name UltraTune in the franchising industry based on the 2019 case in the federal court. Now, although this case looked into a lot of other issues such as good faith and misleading deceptive conduct, it also looked into the marketing fund and non-compliances by the franchisor. Now, one of the big issues was there was not sufficient detail provided by the franchisor about the kinds of expenses the marketing fund covered. The court said in their judgment that a franchisor would be well advised to err on the side of candor when preparing their marketing fund statements. The more detail they provided was saying there should be a breakdown of exactly where the money was spent. For example, if the franchisor paid for television advertisements in the last financial year, they should state what those advertisements were, whether they were run or not. Additionally, if there is money that was spent on AdWords, it should state which kind of AdWords. So the broad catch-all categories will not meet the threshold of sufficient detail in this situation. And as a takeaway, when preparing your marketing fund statement or looking at it, we recommend that franchisors think, would a franchisee who's doing the statement be able to tell with sufficient detail what kind of expenses the fund had in the previous year? If the answer is no, or the idea may not be as clear, then it probably needs to be revised.
Now, there has been so many changes in franchising as of late, and one of the more recent changes is the introduction of the Franchise Disclosure Register, which is the new Part 5A of the code. As a franchisor, you have to now upload certain information to the Franchise Disclosure Register if you have a disclosure document, have provided that disclosure document to prospective franchisees, and if you're a master franchisor, you have to have 2 or more sub-franchisors to need to comply with this obligation. There is, quite a bit of administrative stuff that needs to be done to actually sign up and upload the information. You need to create, have a MyGov ID and have that authorized to act on behalf of the ABN of the franchisor. The Franchise Disclosure Register is live now, as in franchisors can now start uploading information to the site. We would suggest that, get familiar with the site and make sure you understand how it works so you can upload the information in time. All the information has to be uploaded by 14 November 2022, and the required information is the ABN of the franchisor, your name, addresses, the business address, principal place of business, industry codes, and the franchisor's contact details, so the generic email address and phone number. As a franchisor, you can also choose to upload your disclosure document, key fact sheet, and the standard form franchise agreement. If you choose to upload those documents, highlighting it is an option, you have to redact certain information such as personal or commercially sensitive information, as well as details about franchisees. So, the normal information you state as regards to the contact details of all franchisees would have to be redacted. In the franchise sector, there does seem to be a bit of a sense of waiting to see what the new standard will be and whether the majority of franchisors will choose to upload this information. The Franchise Disclosure Register was created with the idea of creating transparency in the franchising sector and providing prospective franchisees a really good tool to see what brands are out there and compare these brands. With this in mind, it's our view that it's beneficial to upload your documents. It does kind of create an air that you have nothing to hide and you're putting your best foot forward and presenting your brand to all prospective franchisees in a really good light. But again, that is optional, but just something to keep in mind. Do also keep in mind that timeline we noted of 14 November and that as of 15 November, all the information goes live. So everything gets uploaded 14 November, the next day everyone, so that doesn't just include prospective franchisees, just anyone who accesses the website can view this information. And if you fail to upload the information, you may incur civil penalties, which Cam is going to speak to now.
Thank you, Annalise. In this webinar, you've heard us refer to civil penalties or civil penalty provisions. Put simply, a civil penalty is a fine that is imposed on a franchisor for breaching the code. The code has always had civil penalties for various provisions, but this year we saw a bit of an upgrade and increase to those penalties from mid-April this year. There were 2 major changes I want to talk about to bring to your attention. The first one was an increase in the maximum penalties that could be I guess, penalized against a franchisor. Now, some of the key, there are more provisions that have civil penalties now than before, and some of these include failure to comply with marketing fund requirements, breaching the significant capital expenditure obligations, as Annalise referred to earlier, breaches of good faith, just breach of disclosure requirements, both updating and providing documents, as well as the prohibition on legal costs that came in last year. And as I said, some of them are new penalties that didn't have penalties before, but all of them, if they were 300 penalty units, they're now 600 penalty units, which comes to about $133,000 per offence. So that's per each breach of the code. That's the civil penalty that could be applied. Now, the changes to the code this year also introduced new, what we call super penalties. Now, these are only in limited circumstances for specific breaches of the code. Now, the super penalty provisions generally apply to body corporates, but they can affect individuals as well. Now, for the super penalty, there's a few ways of working out how much a court should order against a company. And this could be the greater of $10 million or 3 times the value that a franchisor has derived from the benefit of breaching the code. Or if the court cannot determine the value derived from the breach, 10% of the annual turnover of the body corporate for the previous 12 months. You'll see why we call them super penalty. It's for a very good reason. Now, there's one section of the code, the clause 17, disclosure of materially relevant facts, that is now one of the few provisions that is covered by the super penalty. Now, the reason why we want to mention this is because this is one of the sneaky sections that you have to update franchisees during the financial year, which means it could occur in between your annual updates. Now, clause 17 of the code in subsection 1 says that a franchisor must provide franchisee with financial details, including any changes in its financial position or solvency. And this could be declarations of solvency, updated order reports, or any items that would typically get provided with the disclosure document on an annual basis that is done on an interim. Subclause 17.2 has a few more relevant pieces of information that franchisors must provide to franchisees. I highlighted some of the key sections, but there are a lot more that I encourage you to look at. Now, these could include changes in majority ownership or control of the franchisor, if there were any legal proceedings or judgments entered against the franchisor or an associate, which could be companies or directors, if the franchisor or one of its related companies goes into external administration. So again, insolvency is a big ticket item here. If there's a change in the ownership of intellectual property during the financial year relevant to the franchise system, this needs to be disclosed, as well as any court undertaking or ACCC undertaking against the franchisor. Obviously, these are quite relevant matters that need to be brought to a franchisee's attention. And the code says that these must be notified to franchisees within 14 days of becoming aware of those changes. Now, just because there is a certain judgment or certain court proceedings, it doesn't mean everything needs to be disclosed. There are some thresholds that need to be met and I guess geographical requirements. But as a rule of thumb, if one of these things happen, definitely important to seek legal advice and see if you must disclose it. A failure to disclose it can result in a super penalty being awarded against a company, one of those 3 methods of calculation that I set up before, or for non-body corporates, the penalty is $500,000. So definitely worthwhile paying attention in light of the ACCC's focus into the franchising industry that Annalise is going to finish on now.
So, we've spoken a lot about the code today. The ACCC is the body that's responsible for ensuring compliance with the Competition and Consumer Act, which includes all industry codes, including the franchising code. Each year, the ACCC puts out, some key focuses and areas that they want to pay attention to the next year and that they're going to ensure compliance with. This year, the big one is digital marketing and, manipulative practices in the digital economy. That won't affect too many franchisors, we can't imagine. But one of the other focuses is compliance with industry codes and, protecting small consumers, so people at a vulnerable position compared to a stronger bargaining power. Generally, the franchisor is perceived to have a stronger bargaining position in comparison to a franchisee who is generally more vulnerable, a small consumer, and may not understand all of their rights. One of the main purposes of the ACCC always is to, protect consumers, But this year, they specifically called out saying that they're going to pay specific attention to the franchisor and franchisee relationship and make sure that franchisees are being treated fairly. It's important to note that that means not only compliance with the code, which does only apply to franchising, but the entire Competition and Consumer Act. That encompasses many things, and one of those is the unfair contract terms. Unfair contract terms is an area of law that has had a fair bit of movement in the past year as well. Generally, terms are unfair if they're quite one-sided, if they are punitive, so enforce a penalty that's unreasonable, if they're quite excessive or they don't protect the legitimate business interest. It's really important that you ensure your franchise agreement doesn't include these unfair contract terms or a term that may be deemed unfair, as there's now power for a court to rule that if a term is unfair in one agreement, it can be deemed void and unfair in all agreements that term is contained in. So, in a practical sense, as a franchisor, 99% of franchisors use standard form franchise agreements. So if a court deems that one of your terms is unfair, they can then say that's it, it's void in all your contracts and you have to strike it out. There's also a bill currently in Parliament to place penalty if there's unfair contract terms as well. So if that came into place, not only would that term be void, but you would be issued a penalty for each instance of the unfair contract term under the current draft bill. We would suggest you review the franchise agreement now. When you're doing your annual disclosure document update, it's much better to be proactive with these things rather than wait around to see if something changes. So we would suggest, you seek legal advice if you're unsure as to whether this may apply to your current franchise agreement. Another thing to be aware of is the ACCC has clearly taken action and is willing to take action against franchisors. Cam spoke earlier to the UltraTune case, where they brought proceedings against UltraTune. As of late, the ACCC has brought further contempt of court proceedings against UltraTune due to alleged breaches of the court orders. So just be aware of this as a franchisor, that the ACCC has shown they are willing to take the steps required to ensure you comply with these acts. I know we have spoken to quite a lot today, so just to kind of summarize and give you, if you're going to take away anything from this presentation when you watch it back, just really think about, as a franchisor, unless you fall in that exception, start taking steps now to update your disclosure document and key fact sheet. Especially if you have a marketing fund, you'll need to do quite a bit of administrative work to get that information together. So we'd suggest you take those steps now. Be aware as well of the Franchise Disclosure Register. So take steps, if you can, to register your profile now and get familiar with the platform. Be aware of those super penalties and all increased penalties really in your dealings with franchisees, and just be aware that ACCC is focusing on franchisors once again. So you should exercise extra caution, especially in light of the recent cases where the ACCC has proven they'll take action against franchisors. This draws the main part of our presentation to an end. We have spoken a lot. So in the handout section of your webinar panel, you can download our Franchisor Toolkit and Financial Disclosure Fact Sheet. Both these documents are really good resources that reference a lot of the items we've spoken to today, and can act as a nice refresher to summarize the information we've provided today.
Thank you very much, Annalise. We might, or before we go into questions, just let everyone know that we have, as part of our ongoing webinar series, another presentation happening next week on legal essentials for product manufacturers. Might be relevant to your business or might be relevant to your suppliers. Feel free to jump onto our website in the events section to register for that one happening next week. Now, I'm just looking to see if we have any questions that have been submitted. If anyone does want to ask a question based on anything that Annalise and I have said in this webinar, or throw us a curveball and ask a new question, just head over to the chat function of the webinar and you should be able to write to us. I'll just give it if anyone wants to ask anything of us. If not, you can always get in touch with us. We'll have our contact details at the end of this presentation with any further follow-on questions. All right, well, it seems like our webinar covered everything. So I'll just, before we finish up, I'll quickly touch upon, we've just had a question come in. The question is, with unfair contract terms and reviewing franchise agreements, what is the stance with the franchise operations manual? Should that be reviewed too in light of unfair contract terms regime, even if the agreement contains all fair terms, but there is some inconsistency with the operations manual? Thank you very much for that question. I'll address sort of a few items on that. The first point is that the franchise agreement and operations manual should be fairly consistent. There shouldn't be any inconsistencies. Generally, when preparing a franchise agreement, the main purpose is to have the obligation to comply with the operations manual as binding and enforceable against a franchisee. And this can create some interesting situations where a franchisee may not get the operations manual until after they've entered into the franchise agreement, but this is why we have cooling off. So if there is any inconsistency, obviously address that at first. If there is a franchisor who is going to, say, penalize a franchisee for not complying with the operations manual, this should be in the franchise agreement. And the thing we want to keep in mind is whether that penalty is an unfair contract term, or if it will not get covered by the unfair contract term regime, maybe it's to cover the franchisor's reasonable administrative costs or losses associated with the breach. It's not legal costs, but otherwise generally, or if it was reasonably necessary to protect the franchisor's legitimate interest. So, for example, if there was a requirement under the operations manual to notify the franchisor of any issues or emergencies in the franchise business, maybe there was an issue with a customer or there was a product issue, and the franchisee was required to notify the franchisor ASAP. The franchise agreement might have a general requirement for that. The operations manual might go into that in a little bit more detail. The takeaway is, if it can be justified, if it's reasonable, it's unlikely to be a breach of the unfair contract terms. And again, if the franchise agreement requires it to comply with the manuals, but there is something that is unfair, then it's likely that the ACCC or a court would want to have a look at the operations manual. So you can't really get around the unfair contract terms by having all the, sort of harsh restrictions in the operations manual, because they are, an extension of the franchise agreement. I hope that answers your question. If not, feel free to ask a certain follow-up question. All right, what I'll talk about before we finish is how we work as LegalVision. If you've been to one of our webinars before, if you've come across a website, or if you've gone on social media in the last few years, you might have seen some advertisement for us about our membership. Now, the way that LegalVision supports our clients is via our LV Connect Pro membership, which is an ongoing monthly retainer where we basically try and cram in as much of your business as usual legal work that we can. Now, for franchisors, this includes obviously drafting and updating your franchise agreement, whether it's for compliance with the code, changes to your operations, or other developments relating to IP or regulations. We will review your marketing fund for compliance. We will update your disclosure document key fact sheet on an annual basis and interim basis if need be. We can do that review for unfair contract terms to ensure that there's nothing in there that could cause some issues down the track. As well as part of the membership, you get access to our legal advice consultation service, which is having our full range of lawyers on call for any questions that you have about franchising, commercial contracts, corporate, intellectual property, whatever, generally. If you're interested in finding out more about what membership has, you can actually either leave your contact details in the survey that will be circulated at the end of this webinar, or contact us at reply@legalvision.com.au and refer to the fact that you saw this webinar and you're interested in finding out more about it. This is a great time to join as a member of LegalVision, and we're encouraging all of our franchisor clients and new clients to get on board now, especially in light of the updated provisions and penalties and ACCC focus. There's never been a better time to comply. That's all for today. Thank you so much for joining us, and we look forward to seeing you at the next one.
Thanks everyone for your time.